absolutely delighted to have you all join the session today. Our Law Lab for June. For those of you that I haven't met before, my name's Morag Hutchison. I'm an employment partner here at Burness Paull, and I'm delighted to say we've got a guest appearance today from Grace McGill, who is an immigration partner here at Burness Paull. And she describes it as hijacking the session to cover immigration, but I don't think it's hijacking at all. I think it's obviously very worthwhile, Grace, and we're delighted to have you. So session in two key parts today. I'm going to hand over to Grace shortly to talk about the global business mobility routes. I think it's a topic that's obviously just becoming more and more relevant as employers' ability to hire from abroad widens. It's a really relevant topic, and I'm sure one that you'll enjoy hearing all about. Once Grace has done her session, I'm going to pick up on 4 key cases that I'm going to cover. One of them is around about trade union activity. One is around about changing terms and conditions and whether a term is contractual or not, which I know is something that a lot of you deal with and tackle on a regular basis. The third case is about voluntary redundancy and unfair dismissal claims, one that might give you a little bit of fear, but better to highlight it, and then you know that the case is out there. And then the fourth case, to keep you all hanging on till the very end, and some of you may have seen this covered in the press, is the question of whether or not calling a man bald is sexual harassment. So I'm sure you'll all want to hang on to the end to hear that case being covered. As always, if we can ask everyone just to keep yourself on mute throughout the session, that would be brilliant. At the moment, we've got about 130 people on, so it's just to limit the background noise. If you've got any questions at all, though, please feel free to just type them into the chat box, either marked for everyone to see, or if you want to mark them directly for myself or for Grace, we can pick them up. We'll pick up as many of those as we can as we go through the session. And with that, I think that's all my points. I'm going to hand over to you, Grace, to kick off on the global business mobility. Thank you.
Now, if you could just bear with me, I think something has frozen my screens.
I've got your slides up on the screen. That's what I can see, Grace. I think everybody else will be able to see that.
That's better.
See that.
I think it may have been a Wi-Fi, but we'll say that instead of my inability.
Grace,
So
Grace,
hello.
don't upset me like that. You get me stressed.
Just before you bit there.
Sorry,
not gonna lie.
Just before you kick off, there's one question coming to ask if people will get a copy of the slides after the session. Yes, you will. We'll circulate the slides and also the recording for the session afterwards. So, right, Grace, don't be causing me any more stress. On you go.
Your deep breath, absolutely. So, Elaine, could I move on to the first slide, please, being slide 2? So hello everybody. As part of the UK government's Plan for Growth initiative that I'm sure you've all heard about, new global business mobility routes have been created in order to replace existing business mobility provisions, including the creation of a new provision for secondments, as well as a tightening up and expansion of some of the existing routes. Today, I'm just going to have a quick overview of the various routes which opened on the 11th of April and which may be of interest to sit alongside the skilled worker regime, which may be useful to you in the consideration of recruitment of overseas talent. Slide 3, please, Elaine. So the first route to highlight is the senior or specialist worker, and this route is primarily introduced to replace the current inter-company route. It is to permit UK sponsors to sponsor overseas workers who are undertaking temporary work assignments in the UK, and where the worker is a senior manager or a specialist employee and is being assigned to the UK business linked to their overseas enterprise. The route follows much of the same requirements as the previous intercompany route and is not one which leads to settlement, but applicants can bring their dependent partner and children under the age of 18. It does require a valid certificate of sponsorship for the role as issued by the permitted licensed sponsor, which most of you here will be familiar with under the Skilled Worker Management System. The applicant should currently be working for the sponsor group and have worked outside the UK in that sponsor group for a continuous period of 12 months, unless they're classed as a high earner. The sponsor group is defined as being a sponsor and any business or organisation that's linked to the sponsor by common ownership or by control or by a joint venture on which the applicant is sponsored to work, and which needs to be linked to the sponsor licence which is existing in the SMS system before an application is made. If it is, or you attempt to do it after the application is submitted, then it will just lead to a rejection. The salary requirement in this category is being increased slightly from 41.5 to 42,400, with high earners needing to earn in excess of 73,900. Applicants still need to meet the financial requirements as part of their visa application, which will be automatically met if either have been living in the UK with permission for 12 months or longer on the date of application, and they can show their own personal funds, or of course they can rely on certification of maintenance under the certificate of sponsorship. Applicants on this route are usually capped at 5 years, or if it's a high earner, they can stay for up to 9 years. The graduate trainee is much mirrored on this specialist or senior worker route and is primarily there to replace the intercompany graduate trainees route previously used by sponsors. It's designed, of course, for overseas workers who are undertaking temporary work assignments in the UK and where the worker is on a graduate training course leading to a senior management position or a specialist position and required to complete a work placement in the UK. Again, it's not a route to settlement, as most of these new routes are, and the role needs to fall within an accredited occupation code, and the job must be part of a structured graduate training programme with, as I said, defined progression towards managerial or specialist role. Starting salary comes in at 22,100 and must meet the required 70% of the going rate for that specific job type. Salary, it can include a guaranteed basic gross pay and allowances which are guaranteed to be paid for the duration of employment, such as London waiting, or are paid as a mobility premium to cover the additional costs of relocating to the UK. Next slide, please, Elaine, slide 4. The service supplier it replaces a temporary work international agreement route and is for overseas workers wishing to undertake temporary work assignments in the UK, where the worker has, for a cumulative period of 12 months prior to applying, is either a contractual service supplier employed by the overseas service or a self-employed independent professional based overseas, and they need to undertake the assignment in the UK to provide services which are covered by one of the UK's international trade agreements. Again, it's not a route to settlement, but could be attractive because applicants can bring in their dependent partners and children under the age of 18. Not surprising, the applicants must have a university degree or equivalent level technical qualification, with certain services being selected for specified criteria, as we know, home office fashion. And these areas cover chefs, management consultancy, fashion and modelling industries, and sectors, and again, a specified table. It requires a valid certificate of sponsorship issued by a permitted sponsor who must have a contract with the overseas service provider. That contract must be registered with the Home Office and is for a service covered by one of the UK's international trade agreements. How long a person can stay in the United Kingdom depends on the type of trade agreement you're providing services under, whichever is the shorter period between 6 and 12 months. The applicants can apply to extend the service supplier visa if they're still contracted to work for the sponsor who has issued the certificate of sponsorship and have not reached the maximum total stay capped at 5 years, which is common throughout all of these new categories under global mobility. Slide 5, please, Elaine. The UK expansion worker is in fact a new route, and it replaces the sole representative of an overseas business route and is for overseas workers who are undertaking temporary work assignments in the UK, where the worker is a senior manager or a specialist employee and is being assigned to the UK to undertake work-related business expansion. The business, very importantly, cannot have already commenced trading in the UK, although it could be basically created as a separate legal entity. Again, it's not a route to settlement, but again, applicants can bring in their dependent partners and children under the age of 18. It requires a certificate of sponsorship, and the applicant should currently be working for the sponsor group and have worked outside of the UK for the sponsor group for a cumulative period of at least 12 months. There is an exception to this where they're classed as a high earner or a Japanese national seeking to establish a UK branch or subsidiary under a sponsor group under the UK-Japan Comprehensive Economic Partnership. The salary threshold starts at 42,400, which is a change to the previous route where there was no minimum requirement, and it must be equivalent to the going rate requirement specified in the accepted occupation codes. Again, it doesn't lead to settlement, and applicants can stay in the UK for whichever is shorter, in 12 months after the start date of the job on the certificate of sponsorship, or the time given on your certificate of sponsorship plus 14 days. If the applicant wants to stay longer in the United Kingdom, they can extend their visa by a further 12 months, bringing it to a maximum period of 2 years. Slide 6, Elaine, please. This is the secondment worker route for overseas workers who are undertaking temporary work assignments in the UK, where the worker has been seconded to the UK as part of a high value contract or an investment by their employer overseas. It's actually a new immigration route for which sponsors will need to be authorised and cannot be used to supply resources to vacant roles for third parties, nor can this route be used to fill an ongoing routine role or to provide ongoing routine service for third parties, regardless of the nature or length of any arrangement. The contracts must be worth at least £10 million per year and no less than 50 million in total. And the contract must be registered with the Home Office under the sponsored regime. It will be open to applicants who are coming to work in the UK on select contracts, again, not being a route to settlement, but applicants can again bring their dependent partners and children under the age of 18. Last slide for me, please, Elaine, slide 7. I just wanted to touch on this new route, which is called the High Potential Individual. And it's part of the UK's government's commitment to an elite points-based route to attract the brightest and the best to the UK to maintain our status as a leading international hub for emerging technologies. The route opens on the 30th of May and is for recent graduates from top global universities who want to work or indeed look for work in the UK following successful completion of an eligible course of study, which is equivalent to a UK bachelor's degree level or above. The study must have been completed at an institution listed on the Global Universities list, which is compiled every year and consists of eligible non-UK institutions, which are included in the list of the top 50 university worldwide. The route allows for a grant of stay of up to 3 years where you've got a PhD or above, or for 2 years for all other degree qualifications. And it can be attractive as it permits for variation over to alternate sponsored work routes in due course. And as with all the other categories, it's not a route to settlement, but applicants can bring their dependent partners and children under the age of 18. So that's it from me, Morag. Interesting times ahead, again, for the UK immigration status system, yeah, and us attempting to navigate it. And I will pass back to you for employment law.
Thanks, Grace. I was just going to ask, with the kind of new routes that are there, are they all new, or are they kind of, were they existing before? And do you think it's going to make a difference? Will they make things easier? Will they be used a lot? What's your
Whether
there's my
they,
multiple questions.
yeah, whether they make it easier or not, I don't know. I mean, certainly that's what the government and the Home Office are, promoting in this sort of like revamp of post-Brexit, post-COVID, and the labour shortages that everybody's acutely aware of. They are certainly, I think there's maybe 2 new routes that are in there, but more or less some tweaking and some modifications to existing routes. And the Home Office, of course, loves to make everything complicated. So there we are.
And there's just one question there about the presumed companies still need sponsorship license for all these categories. I think that's correct, isn't it? You'd have to have your sponsorship license.
Yeah, absolutely. The whole overhaul is based to try and bring everything within the skilled sponsored regime, and obviously the points-based system.
Yeah, brilliant. Thanks so much. I don't know if anyone's got any other questions on the immigration piece. If you do, feel free to type them in. I'll kick off on the employment side. And if they're easy enough to answer, Grace and I will pick them up. If not, we'll just ignore them. So yes, I promised you 4 exciting cases on employment. The first one, this question of whether you can suspend an employee who goes on strike or not. And the case name for this one is Mercer against Alternative Future Group Limited. So facts here is the claimant was the union workplace representative. The employer alleged that she took time off her shift to go and attend strike, and so they suspended her whilst they investigated that allegation. And while she was suspended, she missed out on overtime, and it was very common for her to do a fair amount of overtime, so it was quite a financial hit for her. The question in the case here, let's start with the relevant legislation first, which is, and those of you that are on these sessions know that I don't normally talk about legislation, but I'm going to give you a section number and an act. So section 146 of the Trade Union and Labour Relations Consolidation Act 1992, that section specifically prohibits employers from subjecting an employee to a detriment for the sole or main purpose of deterring them from taking part in trade union activities. So the interesting thing about that section, though, is that to date it's been widely accepted that trade union activities doesn't cover participation in industrial action, which seems a bit daft in a way. When you talk about trade union activities, one of the first things you would think about is strike action, but the section specifically isn't designed to cover that. And so it leaves individuals in a kind of strange situation where if they're dismissed for taking part in industrial action, then they do have protection elsewhere under the act that I've just mentioned to you. But if their employer takes action against them which is short of dismissal, some sort of detriment, but short of dismissal, they don't have any protection. So for example, if you decided to withdraw discretionary benefits from employees who take part in strike action, they wouldn't be able to bring any claim. So that's the relevant legislation here. In this case, the claimant did bring a claim for breach of section 146 because what she argued was the fact that she was put on suspension was a detriment, the fact that she lost out on overtime was a detriment, and section 146 should be extended to cover industrial action. So if you suffer a detriment because you've taken part in industrial action, you should be able to raise a claim under section 146. And the point that was being made there was just that point I made a moment ago, where there's this gap where an employee is protected if they're dismissed for taking part in industrial action, but there's no protection for any action short of dismissal. I think what's quite interesting about this case is that you have 2 different decisions. So at Employment Appeal Tribunal, the decision there was that section 146 did require to be extended to cover detriment, because otherwise it was a breach of Article 11 of the European Convention on Human Rights, which gives employees and individuals the right to freedom of assembly and freedom to form and join trade unions. And what the EAT argued is, by not providing any protection to employees in the situation where they're subject to a detriment for taking part in industrial action, that was a breach of Article 11. That decision was appealed to the Court of Appeal. And interestingly, this is where it becomes quite political, I think. The Court of Appeal agreed that the fact that there was no protection for action short of dismissal when you take part in industrial action may be a breach of Article 11. But what they said was section 146 didn't provide that protection, and they couldn't interpret Section 146 in a way that would provide that protection. And so their view was, if that was something that needed to be protected in the UK, then it was something that would have to be dealt with through Parliament and through legislation rather than through case law and interpretation. So interesting decision. I think it just, I suppose from an employer's perspective, it's a good decision in that it means that employees still don't have protection if they take part in strike action and they're not dismissed, but there's some action short of dismissal. They don't have protection. There's no right to bring a claim. I don't see the government of the day changing that anytime soon. So I think that will be how the law will sit for some time. There's no appeal against a Court of Appeal decision, so that's where the law will sit. It's something that may change at some point in the future if there's a change of government, but just something to flag to you. So that was the first trade union case. The second trade union case, although actually it's probably more about contractual terms and conditions and when you can deem an employee to have accepted a change to terms and conditions, but it's a union case to the extent it relates to the whole issue of check-off. So the question here is, can an employer stop deducting union dues from salary unilaterally? And the name of this case is Cox and others against the Home Secretary. So facts of the case: the employer had deducted union fees from wages for a long period of time. It's often commonly referred to as a check-off arrangement, and it simply makes things easier. Well, there's two reasons for it, I guess, for doing it. From the union's perspective, it obviously makes things a lot easier in terms of gathering union dues if it's processed through the employer's payroll rather than something they have to deal with separately. From the employer's perspective, it's often used as a way to get a sense of how many employees are actually paying union dues, so what union membership is like throughout the organisation and where pockets of union membership might be. So that's one of the reasons why employers will often agree to check off. But in this case here, the employer stopped check off without any discussion or agreement. As from 1st of December, they said, that's it, we're not going to deduct union dues from salary anymore. If you want to pay dues, you have to find another way to do that. I'm not sure what drove that decision. It may have been that there was a view that they wanted to reduce union activity within the organisation or discourage union activity, and that was one step or one way of trying to achieve that. So they made that decision as from the 1st of December. On the 5th of December, the union raised a collective grievance against the fact that the union dues had been stopped. The grievance wasn't upheld. They subsequently raised a claim in the High Court, and the claim was for breach of contract, because what they argued was the employees had a contractual entitlement to have their dues deducted from their salary each month, and by removing that or by stopping the check-off process, that was a breach of the employees' contracts of employment. And there was two issues really for the High Court to consider in this case. The first one was there indeed a contractual right to check off? Was the employer under an obligation contractually to check off salary each month? And then the second question was, well, even if there was a contractual right to check off, the employees continued to work after the employer stopped the process on the 1st of December. So did that mean that they had accepted the change to their contract of employment? So on that first question, and I think this is really interesting, I always say that, sorry, those of you that have joined these sessions with me, I always say this is a really interesting case, but I think this is really interesting in relation to terms and conditions and being very careful how you draft your documentation, staff handbook, etc. Because on the first question of whether or not the right to check off was contractual, obviously what the court looked at was any documents that dealt with that right. And the provisions around about deducting salary were contained within the staff handbook, which was stated as being non-contractual, as is commonly the practice. But what the High Court looked at was, or what they said was, they felt that the right to deduct or the check-off process was contractual, because when you looked at the wording of the staff handbook, although it stated it was non-contractual, the wording round about check-off was of a contractual nature, which I thought was quite an interesting conclusion. They also said it didn't conflict with any other provisions in the documentation to deem it contractual. But the other thing that they said, which again I think is quite interesting, is they said the provisions about check-off were contained in a document that contained other legal provisions. So because it was within a staff handbook, which, although said non-contractual, some of the provisions felt very contractual and very legal. They were of the view that the unions could assert that there was a contractual obligation to check off each month. There's also, of course, the argument of it becoming an implied term. You know, if it's something that the employer had done over a prolonged period of time, and it's something that everyone expected to be done, had it become implied into the contract through custom and practice as well. So the answer to the first question from the tribunal was, or from the High Court, sorry, was yes, there was a contractual obligation to carry on check off, and so by stopping that unilaterally without agreement, that would be a breach of contract. The second question, and this is something that we're often asked about, is this question of, but surely had the employees not accepted the change, because although the employer stopped the check off, the employees continued to work for their employer, and therefore they could be deemed to have accepted the change. And there, what the High Court said was, if an employee is continuing to work for the employer, but there's an explanation, or something else, they've taken some other form of action, then they can't be deemed to have accepted the change. So specifically what the High Court said here was, yes, the employees had continued to work for the employer, but a collective agreement had been submitted on their behalf, which indicated that they were unhappy with the change to their contractual terms. So although they continued to work and they didn't protest on a day-to-day basis, they had submitted their collective grievance, and that was enough to demonstrate that they weren't accepting the change, although they continued to work under the arrangements that were put in place. And actually, the other argument the employer ran was, well, they must have accepted it because they put alternative arrangements in place. And again, what the High Court said was, but the fact that they put alternative arrangements in place didn't supersede the fact that a collective agreement had been submitted on their behalf, lodging concerns about the fact that the employer had stopped the check-off process. Excuse me. So on the face of it, it looks like a trade union claim, but actually the kind of key factors, I think, which apply obviously on a much wider basis in relation to when is a term contractual, what do you need to look at? And I think it's interesting that the High Court here have said you look at the document that it sits in, you look at the nature of the language. Those are factors that can be taken into account. And then also dealing with this question of when an employee can be deemed to have accepted a change if they carry on working. And if they've done something else which would indicate that they're not accepting the change, that will be enough for them not to be deemed to have accepted it. Okay, so it just kind of reinforces how difficult it is and actually how unreliable it can be for employers to make a change and not get explicit consent and argue that an employee is deemed to have accepted it. The other kind of stuff that they spoke about in the tribunal, in the decision as well, actually was an employer is more likely to be successful with the argument that an employee is deemed to have accepted a contractual change if they've been offered some sort of benefit. They've been given some sort of enhanced contractual terms at the same time as other contractual terms being taken away. So interesting case. Now, I see this question: how can an employer guard against contractual language in a non-contractual document? What does this look like in practice? Oh my goodness, that's $1 million question. But it's a good question. I suppose it's about, increasingly when we talk to clients, they talk about writing contracts in plain English, in day-to-day language, and you see whole projects where contracts of employment are rewritten or staff handbooks are rewritten to sound much more conversational rather than legal. So that kind of approach would be one way to try to limit the likelihood. No, not at all. Don't apologise. I love these questions. To try to limit the likelihood of a contract being or wording being viewed as too contractual. So thank you for the question, keep them coming. So that's the second case. Third case, this is a beauty. I think the question in the third case is, let me find my notes for it first before I go on to ask it. Can an employee who's volunteered for redundancy claim unfair dismissal? Okay, so White against HC1 Oval Limited is the name of this case. And the facts of this case are housing association, 2 part-time receptionists and a full-time receptionist who also do reception duties and they also do admin duties. The employer decided that they needed to reduce the amount of people who were doing reception and admin duties, and so they went through a redundancy process or kicked off a redundancy process. The claimant here was provisionally selected for redundancy. So they started the consultation, they'd applied selection criteria, and the claimant was provisionally selected. Once she had been notified that she'd been selected for redundancy, she requested voluntary redundancy instead. So she went to her employer. I imagine in my head the scenario is she's gone to the employer and said, I don't want to go through this process. I've been selected anyway. Can I just volunteer for redundancy and get this sorted? And the employer agreed to grant voluntary redundancy. So off she went. Employment terminated on the grounds of that she had applied for voluntary redundancy. And then she then put in a claim for unfair dismissal. You can imagine the response of the HR team I expect when they received the employment tribunal claim. Because of course what they argued was, well, this claim's a nonsense, because if you'd applied for voluntary redundancy and it was granted, you weren't dismissed. How can you bring a claim for unfair dismissal? What the employee argued was that the dismissal was unfair, both in terms of process, but also substantively. And what she said was, just before the redundancy process kicked off, another part-time receptionist who had just joined the organisation fairly recently was moved to full-time and was given a higher pay and was given extra duties. And she felt that that had been manipulated to take that individual out of the selection pool. So that was one of her arguments. Second argument was, during the redundancy consultation process, before she said she wanted to apply for voluntary redundancy, there was an administrative role was created and she wasn't given the opportunity to apply for it or wasn't offered it. And then the third argument she ran was, not long before the redundancy process started off, she had been given extra administrative duties, but had complained about the fact that she wasn't getting paid more for carrying out those duties, and she'd raised a grievance. And what she argued was the real reason for the redundancy was the fact that she'd raised a grievance, and so the whole process was a sham. The employment tribunal said this case has no reasonable prospects of success, so they struck it out on the basis that the employee had left on the grounds of voluntary redundancy. She hadn't been forced, she wasn't forced to exit by the employer. The employer hadn't ultimately concluded a redundancy process, and that was appealed to the Employment Appeal Tribunal. And what the Employment Appeal Tribunal said, you know where I'm going to go with this, I think, don't you? What the Employment Appeal Tribunal said was, no, it wasn't right for the Employment Tribunal to throw the case out on the basis that there was no reasonable prospects of success. They should have gone to a hearing to consider the factors that the employee had raised, notwithstanding the fact that on the face of it, she had volunteered for redundancy. It looked like there was enough there to argue that potentially it was an unfair dismissal situation. So in terms of learnings from this case, I've written down in capital letters on my notes here, always get a settlement agreement, because of course, if we'd entered into, or if the employer had entered into a settlement agreement with the individual, she wouldn't have been able to bring a claim for unfair dismissal. Now, that's a bit harsh of me to say always get a settlement agreement, because what we don't know here is whether she was offered any enhanced terms to volunteer or not, or if she was just given statutory anyway and they just accepted her voluntary application. But certainly if you're looking at paying enhanced terms, even if it's a voluntary redundancy, if you think there's a risk or there's, you're just there's just that gut feeling that there could be an issue, then you might want to enter into a settlement agreement. I think one of the factors that you would take into account here, though, and one of the things that kind of came into my mind when I was reading this case is, I wonder if the position would have been different if the individual had volunteered right at the very outset, before going through a process and before being selected for redundancy. So the scenario where you announce that you're going to have to look at some cost savings, you want to invite applicants for voluntary redundancy first before you go down a compulsory route. I think if someone came to you at that stage and volunteered and that was accepted, it would be very difficult for them to subsequently pursue an unfair dismissal claim, because they wouldn't be able to show that there was something about the process or that they had been treated unfairly in any way. I think it's obviously very relevant in this case where the employer had gone a fair bit down the process already and the individual had been notified that she had been selected for redundancy before the application for voluntary redundancy came in. Okay. So, interesting case. I'm going to just now go, let me just check. I think there's another question here. Give me 1 sec while I scroll up. Yeah, if it's statutory terms, can you still not try and get a settlement agreement signed off? It's a good question, Louise. Yeah, it might be unlikely right enough, but worth a go. Oh, I love your optimism. You could ask an employee to sign a settlement agreement, even if it's statutory only. If they went your risk is that they go and see a solicitor, which obviously they have to do before the settlement agreement can be legally binding, and the solicitor says, I wouldn't sign that. You're not getting paid anything over and above what you're contractually entitled to. So why would you sign a settlement agreement? Now, the employer might argue, but what you are getting is you volunteered for redundancy and we're agreeing to, to your request that you get to volunteer. So that's what you're getting. You could argue, I guess, otherwise you might not have been selected and you might not get your redundancy terms. So yeah, there are some scenarios where it might work, but I think it would be fairly limited. Okay. And then the last case I promised you, which has kept you all hanging on to the end. I know Grace is very excited about this case and now wants to become an employment lawyer, where the question is calling a man bald sexual harassment or not? As I say, some of you might have seen the coverage of this case. It's called Finn against the British Bung Manufacturing Company and King. I have to say, I then Googled the British Bung Manufacturing Company because I was intrigued to find out what they actually do. And what they do is they make the corks, basically, that you stick in the top of bottles. So they supply the brewing industry with bungs, which I've learned today. So there you go. Obviously, the interesting thing about this case name is it's Finn against the British Bung Manufacturing Company and King. So the individual has brought a claim both against his employer and against the individual that he says made the comment against him, which, as many of you will know and be aware, an employee can do that. They can bring the claim against the company and also against the employee. And I often say to clients of ours, if you're acting for the employee, that's it's quite a good tactic from a settlement perspective, because it's quite emotionally draining being involved in a case on behalf of the company. But if one of your employees has a claim brought against them as an individual as well, it kind of raises the stakes quite a bit. And so it's a tactic that's often used by employee solicitors in order to raise the stakes and possibly help with settlement discussions as well. So, right, stop talking about all the background, Morag, and tell you the facts of this case, which I'm sure you're all desperate to hear. Mr. Finn and Mr. King had been having arguments for quite a period of time. They'd had, the way it's described in the cases, they'd had several arguments between them, and it culminated with Mr. King calling Mr. Finn a bald ... and I'll let you fill in the dots. And Mr. King said he admitted he did it, and he admitted that he wanted to insult the claimant. They'd had enough. That was the argument, and he knew exactly what he was doing. So that was the background facts. Mr. Finn then brought a claim for harassment on the grounds of sex, and the employer argued, well, hold on, women can also be bald, so how can you argue that the comment was directed at Mr. Finn because of his sex? It wasn't a comment that was related to Mr. Finn's sex. The relevant legislation here, as many of you will know, my goodness, this is the second act I've quoted today, so it's not like me at all, it's the Equality Act 2010, the harassment provisions within the Equality Act. For someone to bring a claim for harassment under the Act, they have to show a number of things. They have to show that the conduct was unwanted. They have to show that it's related to one of the protected characteristics. So in this case, Mr. Finn had to show it was related to his sex. The tribunal has to be satisfied that the conduct had the purpose or effect of violating the claimant's dignity or creating an intimidating, hostile, degrading, humiliating or offensive environment. And the tribunal also has to be satisfied that it was reasonable for the claimant to feel that their dignity had been violated, or that the environment that I mentioned there had been created. So they're the various factors when you're looking at a harassment claim. And as I say, the argument of the respondent in this case was calling someone bald is in no way related to sex. What I thought was quite interesting about the decision in this case was the tribunal held that baldness was much more prevalent in men than women, and therefore it could be argued that calling someone bald was related to their sex. But the point that I thought was particularly interesting when you look at the case is the tribunal panel was made up of 3 bald men. you couldn't write it. And so it's specifically noted by the panel that all three of them were men and all three of them were bald. And I just have this vision of the three of them sitting on the sitting on the panel, and one saying, "And you're bald, and I too am bald, and you are also bald." So it was specifically noted that baldness was much more prevalent in men than it was in women. The tribunal also held, so they held that it was related to Mr. Finn's sex. They held it was unwanted conduct. Mr. King had been very clear that he had deliberately said what he said with a view to trying to upset Mr. Finn. And they also held that it was reasonable for Mr. Finn to be upset by the comment that was made. So on that basis, they upheld the allegation of sexual harassment on the grounds of sex, and Mr. Finn succeeded with his case, his claim. So I think, again, just 2 points to highlight there. I think the first one is it demonstrates, again, the scope of the harassment protections within the Equality Act. You know, it's quite a wide interpretation of harassment potentially, but that one-off incident has been held to be harassment, and the fact that calling someone bald has been held to relate specifically to their sex. So, and I think it demonstrates a trend in these harassment claims. Some of you will have heard us talk before about the recent case of a female employee where her male boss had said to her, "Are you menopausal?" And that was held to be harassment on the grounds of sex. And the kind of discussion there was it enough that there was one comment made for it to be harassment? And the tribunal's view was yes, one comment was sufficient to create that intimidating, hostile, degrading environment, etc. So I think that's one point that comes out of this case. The other point that comes out of this case, of course, is that it's interesting to see that the sex of the harasser is not always relevant in these kind of claims. You know, you tend to see claims on the grounds of harassment, sexual harassment, being claims where the allegation is a male has harassed a female or a female has harassed a male. But obviously in this case, what you've got is two males, but that didn't mean that the fact that the comment itself wasn't related to sex, and it meant that Mr. Finn could still succeed with his sexual harassment claims. So an interesting one, I think. And I think we've got another question here. Let me just quickly scroll up. Oh, no, it's not a question, just a comment from Louise, thank you. Okay, so my goodness, we've finished in super quick time today, but that's the 4 cases that I wanted to cover. I hope you found them interesting. If anyone's got any other questions at all, again, feel free to drop them in the chat box, or if you want to pick up with myself or Grace separately after the session, I'm delighted to answer any queries that you have. And otherwise, you've got, oh, Elaine, I was just about to say otherwise, you've got 17 minutes of your lunch back. Makes you wonder if the other employee was bald, would it have succeeded? A good comment, actually, a good comment. I think it probably would have still succeeded because the tribunal is likely to still have come to the conclusion that referring to someone as bald was related to males more than females. So yes, I think it probably would have. Right, 16 minutes of your lunch back. I hope you enjoyed that and have a good day. Thanks very much for joining us today. Take care now.